I mean, you can't just say to me, Judge, it's too much money. You're not giving me a reason to say he overcharged you. You're not giving me a reason to say anything about the installment payment order because I don't know anything about it. I don't know how much you make. I don't know where you work. I don't know how many expenses you have.
What started as a disagreement over legal fees quickly became a tense courtroom battle. A woman questioned a sudden $9,000 bill after her divorce case, while the lawyer defended every charge. The judge tried to calm both sides, explaining the law carefully, but the emotional pressure and financial stress only made the hearing more intense.
Nichols and Ebert, PC versus Samantha Duclos.
Yes, Your Honor.
Good morning, Mr. Lampkin. Your appearance?
Brent Lampkin on behalf of Nichols and Ebert, PC.
Ma'am, your name?
Samantha Duclos.
Any resolution?
Not yet. I know we have discussed the potential of settlement, but I left it with Ms. Duclos, and I have not heard back from her since we last spoke about settlement. So
Ma'am?
No, Your Honor, we haven't. He offered.
I don't need to know.
Oh, okay. Sorry.
I don't really need to know what he offered. Are you close to accepting it or not?
I am not able to accept the conditions.
And because you don't owe the debt or because you can't afford to pay at the rate he wants you to?
The latter, yes, Your Honor.
So here's what could happen today. If you agree, and I don't care what you do. I can give you dates, we can set it for trial. But if you agree that you owe the debt, it doesn't make any sense to fight it. And there's two prongs of every lawsuit, essentially. One is whether or not the debt is owed, and two is ability to pay. So if you guys wanted to agree to a consent judgment on the total amount or whatever it is, including costs and attorney fees, I'll be happy to swear you to an oath today, and I'll determine how much you can afford to pay on a weekly, bi-weekly, or monthly basis. Does that make sense to you?
Yes, it does, Your Honor.
Do you want to do that, or you want to set it for trial?
My concern was the amount as well. I did question it with them, and that was where everything kind of started to happen. I questioned the amount with Mr. Eberth, who was my attorney at the time. And he said he would look everything over and get back to me. And that's kind of where we left that. So I didn't get a settlement offer from him.
Can I interject here? I want to bring
Of course.
something up with you. Mr. Eberth is on our court management council.
Okay.
They pass budgets. He's the treasurer of Brownstown. I know Mr. Eberth. I want to disclose that it's not going to make one difference to me as to whether or not it's Mike Eberth or whoever else in the world. I'm not going to treat him worse. I'm not going to treat him better. I'm not going to treat you worse. I'm not going to treat you better, but I want to disclose that. And if you have any questions regarding my relationship with him, you can ask me questions.
Okay.
Do you want to ask me any questions?
No, I have absolutely no issues with Mr. Eberth. He was a great attorney.
No, I just want to make sure that you don't have a problem with me handling the case, ma'am.
No, if there's no biases, I have no issues.
Okay. Okay, so tell me how far you guys are apart. Maybe I can help you. If I can't, I shouldn't really be getting involved in settlement negotiations a lot on a bench trial. To be honest with you, I don't do it. But if you guys are real close, maybe I can help. If not, fine. I'll just set it for trial. Do you agree that he did the work that he's charged you for?
I was not sure of that aspect of it. I was concerned that in 2 months, my balance had accumulated almost $7,000. So I was just like caught off guard with that. And so when I
Divorce
reached
was
out,
finalized now, right, ma'am?
yes,
Were there
everything's done.
children?
Yes, there were children.
Okay. But I mean, do you have any questions about whether or not he did the work?
We're happy to try the case, Your Honor, if she wants to do that. And we'll stand by our work. Mr. Eberth will testify. There's also was communication with her a year ago about resolving the balance, and she was supposed to get back to him. He has text messages that he supplied to me and I gave to her to prove that he was in communication with her. She probably just can't afford to pay it. So now she's questioning the charges, and I understand that position, but we're happy to just present that to the court if she just.
So, ma'am, it really is very simple. You can either tell me, Judge, I just want to go to trial. I want them to prove what the fees were, that they were reasonable and necessary to the handling of my case. And, or you can say, you know what, I agree with the amount that they're seeking, and I want to just cover the issue of an installment payment order. It's up to you. I don't want to put you into bankruptcy, but they do
Right.
have the right to have their money paid.
Right.
And so you tell me what you want. It's entirely up to you.
My only concern was the large increase, and it caught me off guard. And I actually reached out to Mr. Eberth first.
Ma'am, if you don't want to settle this, you don't have to settle this. I can just set it for trial if that's what you guys want me to do. It does not matter to me. I'm not trying to pressure you into settling, not settling. I could care less. So I can't resolve that right now. If you think there's an issue that maybe you were overcharged, we'll just set it for trial. If you want discovery, that is the exchange of information, I'll be happy to give you dates on that. Whatever you guys want to do, it's up to you.
Well, I was looking for more of a settlement amount than, because I can't afford to pay the rate he was asking for.
Well, you signed a retainer agreement at that though, right? Did you not, did you not sign a retainer agreement?
I did.
You had to think about that before you sign the agreement. I mean, I know lawyers are expensive, but there's a lot of hidden costs. You know, they're paying secretaries and all these other, office rent, malpractice insurance, postage, phone bills, you name it. There's a lot to that, but.
And Your Honor, this was not a simple matter. It got very complicated, and there were they had reconciled at one point, refiled again, had a pretty extensive mediation. There's a lot of things that we would be presenting.
What was his total fee?
Yes.
How much was his total fee?
Oh, his total fee. I don't know that offhand. I do know the outstanding balance, but
which is
over $9,000 at this point. It is.
Was there a lot of court hearings regarding maybe custody issues or something similar, ma'am?
The final two invoices were for mediation. We had mediation one time, and that was the 6,400.
Yeah,
That's why I was
mediation's
caught off
expensive. They're
guard.
paying mediators, they're paying the lawyers. How much did the lawyer get paid? Do you know, that mediated the case?
We paid the mediator on our own.
Okay. How many hours did he include for mediation, Mr. Eberth or his partner or whoever?
I believe it was 2.5 hours, 3 hours, around there.
Oh, that's not much.
That would
But
be.
he and I paid the mediator directly. I didn't have Mr. Eberth pay the mediator.
As Your Honor probably knows, it's not just the attending mediation and showing up for a couple hours to talk.
Preparing for it.
Lots of that. And there's lots of communication in the we send out monthly statements, Your Honor, that detail everything that we're doing on a file. And she would receive these every single month. And
you tell me what you want to do, ma'am. Do you want me just to set it for trial?
I don't personally want to go to trial, but I cannot afford the terms that he was looking for. I can't afford the monthly rate he was asking.
So that's why I said I would come in. If you agree that you owe the debt, you two can agree to a consent judgment in that amount. I can have a hearing right now for installment payments. I will ask you questions. You can testify. He will ask you questions. I'll determine how much you can afford to pay on either a weekly, bi-weekly, or monthly level or installment payment plan. And if that's fine, we'll continue that now. If not, I'll just set it for trial, whatever you want. I mean, you can't just say to me, Judge, it's too much money. You're not giving me a reason to say he overcharged you. You're not giving me a reason to say anything about the installment payment order because I don't know anything about it. I don't know how much you make. I don't know where you work. I don't know how many expenses you have. So let's take one thing at a time. Do you want a trial or do you want to settle at the rate that Mr. Lampkin agreed to? And I'm talking about the amount that he agreed now, not the installment payment amount. I can
Okay.
handle that separately.
I think I was just in the mental space of Mr. Eberth coming to me with a settlement amount because of the amount. So accepting the amount is difficult.
I'll just set it for trial. Do you guys
Okay.
want discovery or not?
Short period. I don't know that we need much, but maybe it might help to know some more financial information for that portion of the trial regarding ability to pay once we determine what the balance will be for
Give you guys until July 18th to conduct discovery. There will be no ADR. Witness lists in this case are due on June the 18th. Nobody demanded a jury trial, correct?
Correct.
I'm going to set the trial again for August the 24th, and that'll be at 10:30 in the morning. At 10:30 in the morning. Nobody has to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. No voir dire questions, no jury instruction questions. I think that should cover it. Let me just see here. Seven, two. Do you have any questions of me, ma'am? I'm going to send out this pretrial order. You guys should have it the next week.
Yes, Your Honor. What was the July 18th date? What was that?
That's the discovery cutoff. If you want to conduct discovery, you have until July 18th. So if they have documents you might want to see that would bolster your case or defeat their case for attorney fees, then you can go ahead and submit that, whether it's discovery for documents, interrogatories, depositions. It does not matter, okay?
Okay, thank you, Your Honor.
Good luck to you both. Thank you very much. City of Deer Park, 514-397 A, B, and C. Okay, Mr. Granata, your appearance.
Morning, Your Honor. Peter Granata, P78413, MIDC counsel for Mr. Johnson.
Sir, your name? Mr. Johnson, I need your name.
Sorry, Sean Johnson.
Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
All right, for purposes of arraignment, stand mute, wait formal reading.
Yes, Your
On
Honor.
the suspend, what about on these failures to pay?
Your Honor, I've had a chance to talk to Mr. Johnson, and they're on the last time he was supposed to be in front of this court on April 16th. His wife went into labor that day, and he failed to contact the court to let them know that he was indisposed. He was at the hospital with his wife. I believe that she delivered the very next day. But with all that was going on, he failed to get back in touch with the court to try to reschedule that date. And that's the reason for his failure to appear. The reason that his license is suspended is the citations that were written out of Gibraltar, the stop sign, no insurance, and mobile device. As soon as those tickets are paid, he should be able to go back into Secretary of State and get his license back. But unfortunately, Mr. Johnson has got a under financial hardship right now because his wife has been off of work because of her maternity leave and without pay. And they're already in a situation where they're on EDT. I think they have a bridge card as well as some cash assistance from the state. And we would ask the court to consider Even though he had ability to appear, if you look at his criminal history, there hasn't been anything since 2014. And again, the only reason his license is suspended was unpaid tickets. He would ask the court to set a personal bond.
I don't think I'm going to do that for you, Mr. Johnson. Why don't you show up here? I get the fact that your wife went into labor. Did you have the baby?
Yes.
Did she have,
She
is the
ended
baby
up having him
healthy?
early.
Baby healthy?
He was premature and had to stay at the hospital for 2 weeks, but he's home now and doing good.
You got these tickets back in November of 25. You didn't show up for the department rep hearing. You didn't show up for the show cause. You didn't bother contacting the court on that day or subsequent thereto. Now you're in here again. You got a problem with me. Where do you work at?
I usually just do side jobs with my uncle.
Why aren't you working?
After I got the pulled over with the no insurance and everything, that was my mom's car, and she had just passed away right before I got pulled over, so I wasn't even aware that there was no insurance or anything. And it's like 3 weeks later, the car broke down and has since been repossessed, so I didn't have a vehicle.
You live on John R?
What's that? Sorry?
Do you live on John R Street?
John R. Street, yes.
Your Honor, if personal bond is not available, we would ask the court to set as low a cash bond as possible because setting a higher bond means that in effect, based on his financial hardship, it's no bond.
Gotta grow up, son. 2010% on the suspend. And I'll give you a personal bond on the Rockwood cases. We're gonna set those for May the 21st. All of these will be heard on May the 21st at 10 a.m., okay? May 21st, 10 a.m.
Thank you, Judge.
And you gotta post $200. Don't make this worse than it is. If you do this again, I'm gonna call Trent and have him come get you. You got it?
I understand. Thank you.
All these are gonna be on May the 21 at 10. Don't make things worse for yourself, okay? If he wants a court-appointed lawyer, Lieutenant, will you have him fill out a petition for one going forward, please? May 21.
Yeah, you
at
already
10.
did.
Thank you
You already
very
told him I'm
much.
sending the court.
Thanks a lot.
Thank you, Judge.
Thanks a lot, Mr. Granada. All right. Do I have other ones with Trenton? I see.
There was a Trenton case in there.
Well, I know they're all with Johnson.
Yeah, fellow same guy.
Okay, Detective Shapaniak, I guess you're all set, right? Or do you have something else for me?
No, Your Honor, I was just checking in, just make sure.
Okay, thanks a lot. Have a good day. Midland Credit versus Lee Bondernock, 2601321. Who's here for the plaintiff? This is Midland Credit versus Lee Bondernock.
Your Honor, I've not had counsel check in. I have called and left a message with the firm.
Jeez. Time was this scheduled? 9:30? LBNV Funding LLC versus Teresa Roberts, 2601897.
Good morning. Once again, Your Honor, Brian Gruen, GR OEN, P number 56673 on behalf of plaintiff LVNV Funding.
You haven't talked to the defendant, have you?
There was, I think, some type of glitch with the equipment down at the courthouse, so they could not get us talking at all.
Your name, ma'am?
Lee Bondernock.
No, not yet. I'm on another case. I'm sorry. All right. So, ma'am, I'm going to give you dates. You have to file a witness list identifying the names of all your witnesses by June the 18th, okay? there's discovery cutoff. That's the exchange of information. I'm going to set that in this case for July the 18th. Then the trial date will be August the 24th of 26 at 10:30 in the morning. I'm putting down half an hour for trial, no settlement conference. You don't have to file a trial brief. If you choose to file it, you have to file and exchange it not later than 7 days before the trial date. So if they have something you want, you can ask for it. They have to give it to you. If you acknowledge that you owe the debt, you could go in. This is only over $647.95. You agree that you owe that debt, ma'am?
I agree, I owe it, but I don't agree on the amount.
How much do you think you owe?
My credit limit was $300, and I did previously try to make arrangements with them because.
Yeah, but what happens is you start to get late fees.
Yes, and I had.
How much do you think you owe?
Maybe like three something, I don't think.
Maybe like, okay, so one thing great about math, again, there's only one right answer, right? Nobody ever passed the test saying about 300 and something. You go figure out what you owe. I'm gonna give you these dates. Doesn't make any sense to go on if you don't have a viable defense. So figure out what you owe, go back and look at what they charged you, figure out if those charges are accurate. I'll give you these dates. We'll set it for a trial. If you want to talk to Mr. Groen in the interim, you can feel free to do that. And we'll go from there, okay?
I did want to speak to him previously to try to make some kind of settlement arrangements because I am working only part-time and I do have.
If you agree that you owe the amount,
Okay.
and you guys resolve it that, you can also agree on an installment payment plan.
Okay.
And if you can't agree on the amount that you should be paying, that you can afford to pay, then you can file a motion and I'll decide. Okay? So, I mean, I would get on the phone with Mr. Groen here in the next few days, see if he can resolve it. And you guys can submit a consent judgment or a conditional dismissal, whatever you agree upon, and we can go from there. Okay?
Yes.
They're usually pretty good about, agreeing to payment plans. And if they don't, you think you can't afford what they're asking you to pay per week or per month or bi-weekly, then you file a motion and I'll decide. Okay? All right. Any questions? We'll send the pretrial order out here. You get it the next week. Okay? Good luck. So there it
Thank
is.
you, Your Honor.
Thanks, Mr. Groen. Midland Credit versus Lee Bondernack. Is the lawyer not here still?
No, Your Honor, we're trying to make a second phone call, but we're not getting any answer at the office.
Lake Trust Credit versus John Andrew Jancy and Barbara Joe Jancy, 2600737.
Hello, good morning.
Good morning.
Good morning, Your Honor. Andrew Gallster, P 52839 on behalf of Lake Trust Credit Union.
Right. And where is Mr. Jancy?
Can you hear me, sir? I'm here with my wife, Barb.
Oh, I'm sorry. I could see you there now. I'm sorry.
Okay, yeah.
My apologies. Mr. Gallster, you are the third.
Yes.
Okay. And let's see, P number 52839. Okay. Tell me your name again, Mr. Jancy.
John Andrew Jancy.
Ma'am, your name?
Barbara Joe Jancy.
All right, so he thinks that you owe his client $22,607, 667.16, 22667.16. Do you owe that amount?
I don't think so, sir.
How much do you owe?
That I don't know until I get discovery completed. My fundamental question on what I owe concerns reasonableness on the auction of the motorcycle and the timing and the process and procedures that they followed to dispose of that asset.
Okay, here's what I'm going to do. Same thing. Witness lists are due by June the 18th. I'm going to put down 1/2 hour for trial. That will occur on August the 24th at 10:30. You have until July the the 18th to conduct discovery. That is the exchange of information. So you have to file your witness list by June 18th. You have until July 18th to conduct discovery. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. Nobody demanded a jury trial here, right?
No.
Correct, Your Honor.
Okay, so I'm going to give you these dates. You can conduct your discovery. We'll go from there, okay?
Okay.
Is there anything else?
Yes, sir. Will I get the dates like in an email or a letter or whatever?
Yeah, I'm gonna sign a pretrial order. We got quite a few of these today and we're busy, but you should have it without a doubt in the next week.
Okay. Thank you very much,
Okay,
sir.
and it'll have all those dates and make sure you read it carefully. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Okay?
Okay, sir. Thank you.
Have a great day. Thank you
Okay.
Thank you very much, Your
Good
Honor.
luck, folks.
Bye. Thank you.
Thanks. Here you go, Wes. I got Nichols and Ebert versus Samantha Duclos, 2601530. Where do I have Nichols and Ebert or Samantha Duclos?
Judge, they are still in a breakout room. You want me to bring them in?
No. Creekside versus Alice Bester, 2601611.
Judge, they're still in a breakout room as well.
Meadowlands and Lore. Meadowlands versus Noah Lore and Heather Lore, 2601738.
Good morning, Your Honor. Attorney Bears of Salem on behalf of plaintiff.
Good morning. Your name is Lore?
Heather Lore.
So I don't know if it's your husband or what have you. Is Noah your husband?
No, he's my son. He's working. He has a really hard time getting out of work on his schedule.
All right. He was not here last time. I did say he had to be here. What do you want to do? What are you guys doing on this one? What are you doing on this, Ms. Salem?
Your Honor, we did come to an agreement for a consent judgment. I can put the numbers on the record.
Okay, and it'll have to be a default versus Noah, okay?
Correct.
Go ahead.
Rent is $3,129.93. Late fees are $80, and that's 2 months of late fees at $40 each. Court costs are $238.43 for a grand total of $3,448.36 to be paid on or before May 28th.
All right, ma'am, do you understand and agree to those terms?
Yes, sir.
Do you agree that you owe $3,408.36?
Yes, sir.
You understand you have to pay up that amount by May 28th. If you don't, you have to vacate. If you don't do either one of those, then you're going to be evicted. You understand that?
Yes, sir.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You also had 10 days to appeal this. Do you understand that?
Yes, sir.
All right. Do you have any questions for me at all?
I do not.
Does Ms. Salem have your permission to sign your name to this proposed consent judgment?
Yes, sir.
All right, so you send that over, and again, it's a default versus Noah, consent versus Heather, and I will sign that. I wish you well, ma'am. Do you have any other questions?
No, Your Honor.
I'm not sure if it was just my phone breaking up, but the grand total was $3,448.36. I think I heard 3408, but it's 3448.
That's fine. You agree to that, Ms. Lore?
Yes, Your Honor.
Okay, so you're all set. You can send that over. Thank you very much. Good luck to you guys. Good luck, Ms. Lore.
Thank you.
Thank you,
Bye-bye.
Your Honor. All right, have a good one.
Creekside and Bester are still in there, and Duclos and Nichols, right? How about LVNV versus Schmidtke? Charlie
Your Honor,
Schmidt.
Ms. Schmidtke is in the courtroom. This is a transfer case. I've not
Yeah, I
had
see
anyone
that.
check in yet on
Should be
Zoom.
Mr. Groen. Is Mr. Groen still out there? Or maybe he didn't
He
know
is
this.
not, but he may not be who handles matters for the 27th District Court.
Your
Would
Honor,
you-
I'm actually here, Lisa Schneider,
Oh,
covering
okay.
for Stanger.
Okay,
who's
let
the
me call
attorney.
that case. LVNV Funding LLC versus Carly Schmidtke. This is file number 2600660. I'm sitting as a 27th district judge on this. Ma'am, your name?
My name is Carly Schmidtke.
All right, Ms. Schneider, your name again?
Lisa Schneider on behalf of the plaintiff.
All right, so it looks like Judge DeSanto disqualified, I believe, and this was reassigned here. And this is the date scheduled for a pretrial. Did you two talk, Ms. Schneider, you and Ms. Schmidtke?
No, we did not.
Do you agree that you owe this amount that they claim, ma'am?
I do agree. However, I was not properly served.
Why weren't you properly served?
Nobody came to my door and gave me a summons and complaints.
How did you find out about this?
Well, it's a unique circumstance. I actually work for Judge DeSanto. I am a civil clerk. Therefore, I found out about the case by looking at the queue on my file.
All right. Well, I mean, I guess you could file a motion to quash the summons and complaint. But you appeared here, you're really submitting to the jurisdiction of the court. There's not really a reason to drag this on. If you know what I'm saying? And if you want to go into a breakout room and talk with Ms. Schneider, do we have proof of service here, Jennifer? I don't have.
Your Honor, all I received was the notification of the removal. Yeah, the DQ. And I emailed over to 27th and asked if we needed a pretrial, and I was told yes. So that's why one was set. We were never, I didn't receive any answer, proof of service from the 27th. So I just posed the question to them what we needed to do once it was disqualified.
Do you want to talk to Ms. Schneider, see if you can work something out?
I would like to, yes.
Can we get that computer going, John? Was there an issue?
I don't know what the issue was with the, I'll talk to Will and see what the issue.
Okay, let's have you, Ms. Schneider, why don't you try to talk to her? We'll
Okay.
take her to a computer and put you guys in a breakout room, okay?
Sounds
All
good.
right, so you can go with my court officer. Thank you. Now, do I have Midland Credit versus Lee Bond or not? This is 2601321.
Your Honor, we've made 2 phone calls, left 2 messages, and still have no one from plaintiff's office that has checked in.
Miss Bondernock, you can unmute and tell me your name. You have to unmute, bottom left-hand corner of your screen.
Apologies, Your Honor. Lee
That's
Bondernock.
Okay, listen, here's the problem. They didn't show up. Now, I can dismiss it, but they're going to file a motion to reinstate the case. I don't know why they're not here. We called them twice. They should be here. It's very surprising to me that this happens, but the lawyers didn't show up. I can either adjourn this 2 or 3 weeks, or if you want, I'll dismiss it. I'll dismiss it without prejudice, and they'll be able to file a motion to set aside the dismissal, which I'll likely grant, barring them intentionally not showing up.
Your Honor, I talked to Mr. Henry Watts on May 5th, and we came to an agreement. I submitted a letter to the court in lieu of the notice to appear, and we've agreed on a payment schedule, and my first payment was actually made on Friday.
I hate that. Why didn't they send us anything? They didn't send us anything, Jen?
No, Your Honor, I checked the box multiple times today.
I'm going to
see what-
reschedule this for June the 1st. If they don't show up, I'm going to dismiss the case. You can convey that to them. 8:30 in the morning, June the 1st, okay? So
Okay,
that's what
thank
I'm
you.
doing. They got to at least tell us. Just common courtesy in the profession, you know what I mean? I don't need clerks
Right.
having to spend time calling lawyers and begging them to show up, but it happens more than I can imagine, more than I ever dreamed of. But at any rate, that's what I'm going to do. If they don't show up June 1, I will dismiss the case. Thank you. Creekside versus Alice Bester, file number 2601611.
Shit.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff in this matter.
Where is Alice Best? There you are. Good morning, ma'am. Your name?
Good morning. My name is Alice Bester.
So we adjourned this a couple times, Ms. Warbling. We had it, we were in here on April the 20th, and then it got adjourned to May the 4th, and then we adjourned it again. I don't know if she was applying for funding. Did you apply for funding, Ms. Bester?
Yes, I did apply for funding, but everything was denied because I didn't have anything with the current amount that's due. But I talked to the lawyer and she said that with this judgment, I should be able to get funding.
Oh my
Well,
God.
they're not supposed to need a judgment. They don't need a judgment. The summons and complaint are sufficient. I don't know why we get that word sent back to us because it's just not accurate. Ms. Warbling, what do you want to do?
Well, Alice, I read what was owed and she indicated she was in agreement to either pay by money order by 5/20, by on or before 5/28, or she was going to leave.
All right, you want to give me the breakdown?
Sure. The rent to retain was $4,889.73, and then court costs were $191.07, and the total is $5,080.80.
All right, so did you two talk about a consent judgment or a conditional dismissal? Which was it?
We talked about a consent judgment.
So, ma'am, she tells me that you agree that you owe $5,080.88. Is that true?
That's true.
Do you understand you would have to pay this on or before the 28th of May or vacate? If you do neither one of those things, then you're going to be evicted. They're going to submit an application for a writ. I'm going to sign it and you'd be evicted. Do you understand that?
Yes, I do.
You agree to all those terms?
Yes, I do.
Does she have your permission to sign your name to the proposed consent judgment?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
You fully understand everything?
Yes.
Any questions at all?
No questions.
Okay, Ms. Warbling, you can submit your judgment. Have a great day, you two.
Thank you,
very
Your Honor.
much.
Have a good day.
Do I have Nicholas?
There's P 88829 on behalf of the plaintiff.
Is Tyra Ford here?
Yes,
Oh, I'm sorry, ma'am. Your name?
Tyra Ford.
All right. Did you two go in a breakout room and speak this morning, Mr. Evers?
Yes, we did, Your Honor, and we did come to a settlement agreement by way of a conditional dismissal. If the court would like to hear the terms.
Sure, go ahead.
Thank you. We've come to an agreement that defendant shall pay plaintiff by and through their attorneys the sum of $5,525.13, with payments of $175 every month starting June 19th of 2026. If plaintiff fails to receive payment, both parties have stipulated to setting aside the conditional dismissal and entry of consent judgment for the amount of $5,600.13 less any payments made to date.
All right, so, ma'am, do you understand what he just said?
Yes, sir.
So this will be a conditional dismissal with agreed upon debt being 5,525.13 to be paid at the rate of $175 per month every month beginning on the 19th of June and the 19th of every month thereafter until paid in full. So long as you make that payment timely, the case will remain dismissed. And once you pay that amount in your increment of $175 payments, the case again will remain dismissed. If you miss a payment, then as I understand it, there's going to be, the total amount of the debt will be $5,613 less any payments made. Is that right, Mr. Evers?
Yes, Your Honor.
Do you understand and agree to those terms, ma'am?
Yes, sir.
And does Mr. Evers have your permission to sign your name to this proposed conditional dismissal?
Yes.
All right. Do you have any questions? You understand everything?
Yes, sir, I do.
Since you're unrepresented by an attorney, I do want you to understand, if you don't understand something, you have 3 business days to come in here and fill out a motion to set aside the dismissal. You also have 10 days to appeal. Do you understand that?
Yes.
All right. Any other questions?
No, sir.
Anything else, Mr. Evers?
Just one thing for the record, Your Honor. I did have a chance to get Miss Ford a copy of the conditional dismissal, and I've received an e-signature on that. So I did not need a permission to sign.
Good enough. Thank you very much. Have a great day, you two. Thank you.
Thank you. I will submit it to
you.
the court.
Thank you. Kerning Advertising versus Maverick Fence, 2504871.
Your Honor, if I may, we did get something that the discovery is no longer needed. It was paid.
Okay, I'll
It
just
just
make a
came in.
note.
Thank you.
Judgment paid in full. Discovery hearing dismissed. Are they going to submit a satisfaction of judgment on that then, Jennifer?
Yes, I will double check that they're sending one in.
If they don't, we will, okay? But let's make sure it's paid. So it'd be
Sure.
best if they do it since it's not coming through the court. Thank you. JP Morgan Chase versus Sherry A. Nadalny, aka Sherry Cernan, 2600079. Appearances, please.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff JP Morgan Chase.
Good morning, Your Honor. Nicholas Rada, P68328, on behalf of the defendant.
Good morning. Are you in Philadelphia, Mr. Reyna?
No, Judge, I'm actually in Grand Rapids.
I thought so, but they got the Philadelphia. I just wondered. I watched the PGA. It looked great.
Okay.
Anyway, okay. Did you guys resolve this or do we just need dates?
We just need dates, Your Honor. Defense working in conjunction with the debt settlement company. The debt settlement company is located in Philadelphia. So maybe they saw the golf outing.
Yeah. Yeah. Okay. You got 56673, Mr. Reyna. Let's see. What's your P number again, Mr. Reyna?
68328.
Okay. All right. So give me 1 second. All right. So today is May the 18th, June the 18th, July the 18th. I'll give you for discovery 8 cutoff.
In a courtroom built on justice, every decision carries weight far beyond the walls of the court. Today, the law was not only enforced, it was understood with wisdom and humanity. The judge looked beyond mistakes and recognized effort, growth, and the fight to rebuild a life. That is the power of true justice, not just punishment but fairness guided by compassion. The courtroom became a place where hope still mattered, where second chances were earned, and where respect for the law stood stronger than ever. Moments like these remind us why justice systems exist: to protect, guide, and give people a path forward.